Well, good morning to everybody and welcome to this preliminary hearing which marks the start of our final tranche of impact hearings. Before I hand over to Mr. Gale, I'd like to thank all of those who have shared information with us already, whether that has been by providing a witness statement or by means of documentation or by engaging with Let's Be Heard, the inquiry's public participation project. I'm delighted to be able to report that Let's Be Heard was able to gather experience from almost 12,000 people and analysis of those responses is already underway. I'd also like to thank the witnesses who will give evidence during the coming impact hearings. I am well aware that coming to give evidence in public can be both challenging and emotional. It's vitally important to me and to this inquiry that the impacts of measures taken during the pandemic are heard and understood. All of this information helps to inform the inquiry's investigations, including the decisions taken by Scotland's leaders and how those were implemented. As usual, transcripts of our hearings will be published on the inquiry's websites, along with the witness statements and documents. Any directions or orders, including restriction orders, that I have made or will make in the future will also be published on the inquiry website. If I make any specific restriction orders, I will notify those at the hearing on the day. We may choose to protect third-party information for reasons of confidentiality by redacting statements or stopping the hearings if third parties are named. Finally, may I remind you that the inquiry proceedings are broadcast on the inquiry's YouTube channel and recorded to be watched later. Video cameras are located at the rear and sides of this hearing room and face those that are speaking. You should be aware that members of the public attending our hearings may be captured occasionally on wide-angle or room overview camera shots. Now, following Mr. Gale's statement, which he's about to embark upon in a moment, there will be an opportunity for legal representatives to ask questions related to the matters covered in this preliminary hearing. But I'd now hand over to Mr. Stuart Gale, KC, who will provide more detail of how we intend to conduct these hearings. Mr. Gale.
Thank you, my Lord, and good morning. Good morning, ladies and gentlemen, and good morning to everybody who is watching us on our YouTube channel. As many of you will know, I'm Stuart Gale, KC, and together with Laura Ann van der Westhuizen, KC, we are the co-lead counsel to this inquiry. And I'm appearing today with my colleagues in the inquiry counsel team, Mr. David Turner, who is on my left, Ms. Barami, who is behind me, Mr. Stephen, who is behind me, and Mr. Dunlop, who is also behind me. The inquiry counsel team also consists of Sarah Traynor, advocate, and Dennis Edwards, advocate, and I mention them because they will be involved in certain of the hearings as we progress in future weeks. We are, as ever, supported by our task by a team of solicitors and paralegals, led in this instance by Deputy Solicitor to the inquiry, Lindsay Patterson, who is on my right, working together with a dedicated team of support staff. And at this stage, I would like to particularly thank both Mr. Turner and Ms. Patterson for the work that they have put in the case of Mr. Turner, for the strategy and the structuring of our investigations, and Ms. Patterson for arranging matters and leading us to the point where we are approaching the presentation of evidence. Today's preliminary hearing forestalls the final set of impact hearings arising out of the inquiry's 4 investigative portfolios, and perhaps counterintuitively, that is in respect of Portfolio 1. Portfolio 1 has been referred to as the public sector response, but in fact encompasses all parts of the strategic response to the pandemic, which do not fall within the other investigative themes. 3 blocks of evidential hearings have been already announced. Firstly, hearings into the subject of justice. Those hearings will be held between the 18th and the 28th of February. Secondly, worship and life events. Those will be heard between the 29th of April and the 2nd of May. And finally, equalities and human rights, which will be heard between the 10th and the 20th of June. And the purpose of today's preliminary hearing is to explain, firstly, the scope of those upcoming hearings, and secondly, the procedural matters detailing how these hearings will be conducted. Can I first of all refer to the matter of core participants and those with leave to appear? 32 core participants have been designated for the purposes of Portfolio 1. And obviously we are joined today by legal representatives and other representatives of many of those core participants. Leave to appear applications have been or will be invited in respect of each separate blocks of Portfolio 1 impact hearings. The only core participants who have been granted leave to appear, only core participants who have been granted leave to appear will be treated as core participants for the purposes of any particular block of hearings. In opening the individual blocks of hearings, Counsel leading in relation to those blocks of hearings will inform your Lordship as to the identity of any core participants with leave to appear in those hearings. And I now turn to the scope of the Portfolio 1 hearings, and firstly the context. It may be of assistance to explain the background to these hearings. And in particular, I'd like to address briefly the inquiry's approach to in-gathering evidence, and in particular the types of evidence and the order of investigations. And secondly, Let's Be Heard, the inquiry's public participation project. Thirdly, the inquiry's terms of reference. And fourthly, the inquiry's investigative portfolios and the interaction between them. Looking first to in-gathering evidence, I'll come to discuss the inquiry's substantive terms of reference shortly, but it perhaps does not require detailed explanation to appreciate that the task set by the Scottish Government to this inquiry is an extensive one. As has been said both by me and by my co-lead counsel, Ms. van der Westhuizen, this is the largest public inquiry ever to take place in Scotland. The pandemic affected everybody in the world. It affected every person present in Scotland during the pandemic, whether a citizen or not. And each such person has evidence that might fall within the scope of the inquiry's work. Paragraph 6 of the inquiry's terms of reference requires your Lordship as the Chair to provide reports to the Scottish ministers as soon as is practicable. And also in terms of section 17.3 of the Inquiries Act 2005, your Lordship is required to act with regard also to the need to avoid any unnecessary cost. With these duties in mind, it is neither practical nor necessary for the chair to hear every piece of evidence that might be within the scope of the inquiry, let alone for all such evidence to be heard in oral hearings. Turning now to the types of evidence. The inquiry has adopted a range of approaches to the ingathering of evidence. These include issuing what are termed Section 21 notices, which require documents and other evidence to be produced, taking witness statements, Rule 8, requests, which are for the voluntary production of evidence, surveys, and inviting witnesses to roundtable discussion meetings. All this evidence is being collated and summarised for your Lordship's consideration. In this context, it can be seen that oral hearings provide just one string to the inquiry's bow. And I would wish to emphasise, as we indeed have done before, that there is no hierarchy in the manner in which evidence is ingathered. The evidence that will be presented in the oral hearings is intended simply to provide your Lordship with a representation of the type of evidence being received and provide some direct insight into the experiences of the individuals and organizations affected by the pandemic within the various contexts identified. Ultimately, it is intended that all this evidence forms the basis of narrative records of the impact evidence, which will be published following the oral hearings. Core participants with leave to appear at a block of hearings will receive extracts of any narrative record before it is published and may be invited to provide comments thereon. I turn now to the ordering of investigations. Your Lordship determined some time ago to commence investigations by looking first at the ultimate impacts of the COVID-19 pandemic and the strategic response on members of society. And before turning to the implementation of the strategic response by public bodies and others, and finally the decisions of the Scottish Government directing that strategic response. This approach is consistent with your Lordship's commitment in this inquiry to taking a person-centred and human rights-based approach to the task which is before your Lordship. It also allows the inquiry to be in a position of a full and retrospective understanding of the consequences of decisions, both strategic and implementing, when taking evidence of decision makers. This will best promote the aims of this inquiry. Your Lordship has already mentioned Let's Be Heard, and I would like to just add a few comments about that. As again we have mentioned in previous preliminary hearings, Let's Be Heard was set up at the very outset of this inquiry to give everyone affected by the strategic response to the COVID pandemic in Scotland the chance to share their experiences directly with the inquiry. Let's Be Heard is a central component of the inquiry, and its team members work closely with colleagues in the legal team in relation to engagement with organizations and individuals. Let's Be Heard has the capacity to gather and collate individual accounts of personal experiences on a scale that the inquiry simply would not be able to go through and carry out in more traditional means of inquiry in hearings and statements. As your Lordship has said, Let's Be Heard has now heard from almost 12,000 people from every local authority in Scotland. These experiences will sit alongside and augment the evidence that will be ingathered in the upcoming hearings. Can I turn now to the terms of reference? Looking at the context and within which the upcoming hearings sit, it is necessary to look at the substantive terms of reference. Again, as everybody is aware, the aim of the inquiry is set out in paragraph 1 of the terms of reference, and it is to establish the facts of and to learn lessons from the strategic response to the COVID-19 pandemic in Scotland. The scope of the inquiry's investigations is then set out in paragraph 2, and it is to investigate the strategic elements of the handling of the pandemic relating to 12 specified areas, and I'll return to those areas when discussing the inquiry's investigative portfolios in due course. The inquiry can only consider devolved matters. With the exception of pandemic planning, the inquiry's investigations are to cover the handling of the pandemic between 1st January 2020 and 31st December 2022 only. And it is important to recall that there is that time remit. Notwithstanding those specific dates, it is, however, important to recognize that impacts of the strategic response and decisions taken in the handling of the pandemic may arise at any time. The inquiry will hear, therefore, of those impacts regardless of when they arose. Paragraph 5 of the terms of reference requires the inquiry to demonstrate how a human rights-based approach has contributed to its findings and ultimate recommendations. In terms of paragraph 7, and where your Lordship deems it appropriate and necessary, the inquiry will consider, firstly, the impacts of the strategic elements of the handling of the pandemic on the exercise of convention rights, and secondly, any disparities in the strategic elements of the handling of the pandemic, including unequal impacts on people. And now refer to the portfolios. These are specified in paragraph 2 of the terms of reference. And for the purposes of organizing the inquiry's work, the 12 specified areas of investigation were considered to fall broadly into 4 themes. Each of these themes is being treated as a portfolio of work to be taken forward by a dedicated team within the inquiry. This allows the portfolios to be progressed concurrently. 3 of the portfolios have already progressed to oral impact hearings. These are firstly Portfolio 2, which is in relation to the financial and welfare support to businesses and individuals, which primarily addresses terms of reference paragraphs 2J and L. Secondly, Portfolio 3, the provision of health and social care services, which primarily addresses paragraphs 2G, H, and L. And thirdly, Portfolio 4, Education and Certification, which primarily addresses paragraph 2K. As I indicated earlier, we're now moving towards the final block of oral impact hearings for Portfolio 1, the public sector response, which addresses primarily paragraphs 2A to F. And these, put shortly, pandemic planning and exercises carried out by the Scottish Government, the decisions to lock down and to apply other restrictions and the impact of those restrictions, the delivery of a system of testing, outbreak management and self-isolation, the design and delivery of a vaccination strategy, the supply, distribution and use of personal protective equipment, PPE, and the requirement for shielding and associated assistance programs provided or supported by public agencies. There is obviously an interaction between the various portfolios, and there is a requirement of the avoidance of duplication. From its start, the inquiry recognized that there was a considerable and significant overlap between matters that require to be considered relative to each of the portfolios, and indeed the underlying 12 areas of investigation. And the inquiry has worked and continues to work to avoid duplication wherever possible. This is particularly apparent in relation to the areas falling within Portfolio 1. By their nature, many of the impacts of the public sector response were felt across society and fell to be considered as part of the evidence of Portfolios 2, 3, and 4. That being the case, Your Lordship has determined that Portfolio 1 impact hearings will be limited to topics where a significant degree of oral evidence has not been heard by the inquiry specifically. Can I also make the observation that in terms of our terms of reference, this inquiry must make reasonable efforts to minimize duplication of investigation, evidence gathering, and reporting with any other inquiry established under the Inquiries Act 2005. This inquiry and the UK inquiry have entered into a minute of understanding which commits each inquiry to minimize duplication of work as far as possible to reduce the burden on material providers and witnesses engaging with both inquiries and minimizing value and maximizing value to the public purse. In accordance with this minute of understanding, this inquiry is constantly reviewing material produced by and considered by the UK inquiry on certain subjects so as to avoid duplication of material being investigated and presented in this inquiry. Now to the particular Portfolio 1 hearing blocks. There are 3 blocks of hearings, as I've indicated, that have been scheduled: justice, worship and life events, and equalities and human rights. I will address each of these in turn. The justice hearings are intended to hear evidence of impacts affecting the operation and availability of the justice system. The hearings will cover matters related to both civil and criminal justice. This may include impacts affecting courts and tribunals, policing, prisons and prisoners, victims, children and family hearings, community justice, and rehabilitation. In addition to obtaining witness statements and responses to Rule 8 requests for information, the inquiry has undertaken round-table meetings with a number of organisations and individuals. So far as the presentation of oral evidence is concerned, within the 8 days of hearings that I earlier indicated, your Lordship will be hearing from approximately 41 witnesses. These will appear in combinations of both individuals and panels of witnesses. Witness statements and Rule 8 responses relative to the witnesses will provide the basis for their evidence. Witnesses will be allocated a specific amount of time for their evidence. Accordingly, and to comply with the Chair's duties of cost and to make progress towards early reporting, it is not intended to take these witnesses through the entirety of their written evidence in the hearings. Rather, each counsel who is leading the witness will focus on and explore particular issues of relevance, distinctiveness, or interest. I should say a word about prisoners. The inquiry will not be hearing directly from prisoners in oral hearings. However, prior to the commencement of the justice hearings, Let's Be Heard will be publishing a case study setting out the responses of some 74 prisoners from prisons across Scotland. The inquiry has also taken witness statements from prisoners to inform the narrative account. Leave to appear for the justice hearings, applications for leave to appear, were invited between the 4th and the 29th of November last year. There were 9 successful applications for leave to appear, and they are as follows. The NHS Territorial Health Boards and the Special Health Boards, Refugees for Justice, Scottish COVID Bereaved, Scottish Hazards, Scottish Ministers, the Scottish Police Federation, the Scottish Trade Union Congress, the STUC, Scottish Women's Rights Organisations, and the Society of Messengers at Arms and Sheriff Officers. We move on now to the worship and life events. The worship and life events are intended to hear evidence of impacts affecting the organisation and participation in organised worship and other major life events. This may include the impact of the closure of places of worship, restrictions and conditions applied to religious practices and rites, and major life events such as weddings and funerals, together with support received within related communities. The worship team within the inquiry is making progress and has indeed made progress in obtaining statements for use at the hearings and is holding a number of roundtable discussions. Applications for leave to appear at the worship and life events hearings commenced on the 3rd of January of this year, and the deadline for applications is Friday, the 31st of January of this year. Turn finally to equalities and human rights. Equalities and human rights issues arising from the evidence of witnesses have already been explored in all portfolios. I'm certainly aware from the portfolio of 3 hearings that I've conducted in particular of these issues frequently being raised. And in line with the inquiry's human rights-based approach, It is not, however, intended in this block of hearings to duplicate that earlier evidence. Nonetheless, it is felt that there are significant issues of equality and human rights that have not been fully explored. And to that end, these standalone sessions are intended to hear evidence from equalities bodies and representative groups who can speak to these issues specifically. Given the later hearings, work on this block of hearings is at an early stage, then obviously the other two blocks. An invitation for applications for leave to appear at the Equalities and Human Rights hearings will be issued approximately 3 months before commencement of the hearings, which I've indicated are scheduled for the 10th to the 20th of June. A notice inviting applications for leave to appear will appear on the inquiry's website. Can I now turn to some procedural matters? And I'll address these, if I may, under 5 headings. Firstly, disclosure of documents. Secondly, the hearing timetable. Thirdly, questioning of witnesses and Rule 9 procedure. Fourthly, restriction orders. And finally, opening and closing statements. So firstly, disclosure. On each day of the hearings, the inquiry will publish on its website statements and documents that may be referred to in a witness's oral evidence to be heard on that day. Core participants with leave to appear will receive advance disclosure of those documents. Where possible, the inquiry intends to make that disclosure 1 month in advance of a witness's evidence. Disclosure for the justice hearings began on the 20th of January, and documents to be disclosed for justice hearings continue to be finalized for disclosure. Those will be made available to relevant core participants as soon as possible. Secondly, timetabling. Turning to the question of the timetable that we intend to adopt, impact hearings will generally start at 10 a.m. and finish by 4 p.m. We may occasionally need to start earlier and finish later. The inquiry will sit between 4 and 5 days a week to accommodate witness availability and to ensure that evidence can be heard within the time available. The inquiry will publish a timetable for each week of the hearings. This will set out the identity and times of the witnesses to be called during that week. Where possible, the witness list will be disclosed to core participants with leave to appear at the same time as documentary evidence is made, i.e. 1 month before the relevant week of the hearings, or as soon as possible thereafter. Thereafter, also, the witness timetable for each week of hearings is intended to be published on the inquiry website 1 week in advance. I turn now to questioning of witnesses and Rule 9 procedure. As a general rule, the questioning of witnesses will be conducted by counsel to the inquiry or by the chair. Rule 9 of the Inquiries Scotland Rules 2007 provides that recognised legal representatives, including in these cases those of core participants with leave to appear, may apply to ask questions of a witness. Now, again, your Lordship is mindful of the limited time that is available for oral evidence in the inquiry, and your Lordship is therefore keen to ensure that any questioning is undertaken as efficiently as possible. To that end, your Lordship has issued a notice setting out procedure for any Rule 9 applications to ask questions. This notice is or will be available on the inquiry website. The terms of the notice, it is expected that recognised legal representatives will approach counsel to the inquiry on an informal basis in the first instance if they have any relevant questions or topics that they wish to have put or discussed with a witness. That approach should be made using the dedicated email address referred to in the notice. So if, for example, you don't know the identity of the individual counsel who is leading that particular witness, the dedicated email address is for call participants, and it will be sorted by the inquiry team. The approach should be made no later than 1 week before a witness is scheduled to give evidence, with details of the relevant questions or topics sought to be addressed. In the event that counsel to the inquiry is not minded to put to the witness a question proposed informally in this manner, the notice sets out a formal procedure for applications to your Lordship for permission to examine the witness. Such applications must be made no later than 2 working days before the relevant witness is to give evidence. And finally, the notice also provides that at the conclusion of a witness's evidence, your Lordship will consider further applications to put questions to a witness if information that has arisen during the course of their evidence is deemed to be material, relevant, and new. I turn now to the restriction on the disclosure of information. The inquiry has published, as I'm sure everybody is aware, a General Restriction Order, or GRO as it's known, which applies to witness statements, documents, and other evidence shared by the inquiry with core participants and others during the course of its investigation. The General Restriction Order operates to restrict disclosure or publication of that material prior to publication by the inquiry itself. The current version of the GRO is version 3, which is in force from January 2025. Core participants and others who were familiar with previous iterations may wish to acquaint themselves with the amended terms of the current iteration of the GRO. The GRO is available on the inquiry website. There are currently no further restriction orders pertaining specifically to the 3 blocks of upcoming evidential hearings, or in relation to any of the witnesses to be called at those hearings. And finally, I refer to opening and closing statements. On the 20th of December 2024, your Lordship issued a direction in terms of Section 17 of the Inquiries Act 2005 and Rule 10 of the rules to the effect that, and quoting, core participants with leave to appear at the hearings on the impacts in the justice system, worship and life events, and equalities and human rights, due to commence on the 18th of February 2025, the hearings, will not be invited to make opening statements either in written or oral form. Counsel to the inquiry will instead make an opening statement at the commencement of those hearings. Your Lordship has not made any direction in relation to closing statements relative to the Portfolio 1 impact hearings to date. However, I understand that it is your Lordship's intention to mirror the direction given in respect of the recent education and certification hearings, business welfare and finance impact hearings that allowed for closing statements by core participants with leave to appear to be given in writing by a specified date. Any such direction will be notified to core participants with leave to appear. My Lord, at this stage, that concludes the matter that I would wish to bring to the attention of this preliminary hearing, and unless I can assist your Lordship further,
thank you very much.
My observations.
Thank you very much, Mr. Gale. I'm very grateful. Now, I'd like to invite questions from legal representatives. If any of you wishes to ask a question, please raise your hand. A member of the inquiry team will take a note of your name, and I will then ask you all in turn to ask your question from the witness stand, which is over there. If it is impracticable or would cause unnecessary delay to answer any question at this hearing today, a written response will be provided to all core participants by 5 p.m. on 29th January 2024. That should be 2025. It's a bit difficult to do it in the past. My apologies. So, if there are any legal representatives who wish to ask a question, could you raise your hand now, please? Yes. Very much indeed. Now, Miss Watt, could you please come to the witness box, please, which is there. Thank you. Now, I understand you're a solicitor with Anderson Strathern and you represent the
Royal College of Nursing.
Sorry,
my handwriting.
Was it your handwriting? I apologise. Right. Yes, your question, please.
Yeah. Thank you, my Lord. The question I had is in relation to the asking of Rule 9 questions, and to ask why it is that recognised legal representatives, having submitted questions to Counsel, to the inquiry, whether informally or otherwise in writing, can't ask those questions themselves. For instance, I have come from a couple of years at the Post Office inquiry, and recognised legal representatives ask questions of witnesses. Those questions and subject matters of those questions determined by Counsel to the inquiry, but the recognised legal representatives did ask questions every day of witnesses, and I just wondered what the reasoning was. Thank you.
All right. Do you want to handle that in the first place, Mr. Gale?
No, the procedure that has been adopted thus far in this inquiry has been that in the first instance, these questions that are submitted, whether informally or on a more formal basis, are asked by inquiry counsel of the witness. That has worked, certainly in my experience, and I think in my colleagues' experience, well. It also is an issue of timing, principally, that we wish to progress as quickly as possible, and frequently, as has been Ms. Ward has suggested, I think time is allocated to a particular counsel or solicitor to ask questions. We have chosen not to proceed in that way. It is simply that it be asked by counsel. I should emphasise that it is obviously a matter for discretion of counsel to the inquiry what questions are asked and in the way that they are asked. And that again is a very important aspect where a relationship has been established between counsel and the witness who is being led. I hope that answers the question.
Thank you, Mr. Gale. Can I simply supplement that, Ms. Watt, by saying that you'll of course have noted in the order I've given that there is provision for a dialogue between yourself, for example, and Mr. Gale or whoever the counsel involved is in advance of the question being considered. That gives you or any other legal representative the opportunity to discuss those matters, again, directly, face-to-face or by wire with counsel involved. And if it's any further reassurance, it's not unknown. I'm not saying it happens in every case, but it's not unknown for counsel to discuss with me the matter before making a final determination on it.
Thank you, my lord.
Very good. Thank you very much. Now, are there any other questions? Yes. Thank you. Now, Mr. Bryce, could you come forward, please, to the witness box, stadium?
My Lord, there were two matters which seemed to arise to the Scottish Vaccine Injury Group from the discussion that we've had this morning.
Yes, I was going to first of all say that your name is Mr. Bryce.
Yes.
And you're a solicitor with Lindsay's and you act for the...
Counsel for Lindsay's.
I do beg your pardon. And you act for, represent Scottish Vaccine Injury Group.
That's correct.
Thank you. Yes, two questions then.
As a preface to
I think you should take them one at a time too.
As a preface to the questions, I'd like to express on behalf of the group that we've been very happy with the communication that we've had with the inquiry over the last year. It was something that was focused upon at the opening statement back in October, and we've been very happy with the fact we've got a direct communication. So I imagine that these issues I'm about to raise could probably be resolved informally in the way that Your Lordship outlined, but I'll just put the two questions for discussion this morning.
Thank you.
There are two areas which are of concern to the Vaccine Injury Group, which appear to us to relate potentially to the human rights part of this. And they are to do with the difficulties that some of the vaccine injured have had in terms of obtaining appropriate medical treatment, difficulties in diagnosis, and people often, or at least sometimes, having to pay for their own private treatment. And the second area is to do with civil liberties issues around matters to do with coercion, where people have been subjected to pressure such as vaccine passports and, in some cases, employment mandates, and have subsequently been injured. That's a... So the question in relation to both those areas is it envisaged that these might be matters which could potentially come within the justice the Equalities and Human Rights hearings, 10th to the 20th of June.
Very good. Mr. Gale, do you wish to answer that today, or would you rather that one be dealt with in writing?
I think, my Lord, with that appearing to avoid it, I would like to come back to Mr. Bryce through his solicitors about that. But I would like to take the opportunity to acknowledge that currently the UKI is hearing Module 4 of its investigations, which relate to vaccinations. The terms of Module 4 are considerably wider than our 2D, and we are mindful of that. I would like to assure Mr. Bryce at this stage that the evidence that is being led, and has indeed been led from his clients in the UKI, has been followed very carefully and is continuing to be followed very carefully for all of Module 4. If Mr. Bryce gives us the luxury of hearing all the evidence that is heard in Module 4, we will get back to him with a more formal answer to the question he poses.
I anticipate that there will be communication. There has been good communication in the last year. Thank you very much.
Good. Thank you very much. And thank you for giving us the praise you did at the beginning of your question. I'm grateful for it. Very good. Now, are there any other questions? Very good. In the absence of any further questions, I'd like to thank you all for your attendance here today, which has been very helpful indeed. I'll now adjourn, and we will commence hearing the evidence on the 18th of February. Thank you all very much indeed.
All rise.